Hi, everyone. Welcome to the program. I'm Ben Murane. I'm the Executive Director here at the New Israel Fund of Canada. I'm pleased to have two very special guests with us, whom I will introduce in just a moment. For those of you who may be less familiar, although I see lots of familiar faces joining us, the New Israel Fund is the largest organization in Canada and in the world that advances and protects democracy and equality in Israel. And we do that across a number of areas: human and civil rights, shared society between Jewish and Arab citizens, and combating racism. We focus also specifically on the rights of Palestinian citizens, social and economic justice, and the defense of democracy as a principle itself. And we do that through a series of activities. We do that through grant making. We do that through capacity building. We do that through coalition building and advocacy in Israel and in Canada. So I am very pleased today to have a representative of one of Canada's funded projects in Israel, in dialogue with a colleague here doing very similar work in Canada. I first want to thank the members of our legal circle. These are members of supporters of the New Israel Fund of Canada who have helped put this program together to get out the word, and are public supporters of our work. So I want to thank Amy Block and Morris Green, Ronnie Hoffman, Ari Kaplan, Jonathan Katz, David Lipovsky, Jules Louis, Michael Mitchell, Corey Sheffman, Joseph Steiner, and Hannah Wiseman-Cartier. Speaking with us today about a very important topic, LGBTQ rights and equality, and the intersection of religious freedom and freedom of expression, rights of bedrock democratic rights, and when they come in conflict with each other, of course. I have with us Orly, Erez-Likhovski, and Noa Mendelsohn Aviv. First, I'll introduce Orly, and then I'll introduce Noa, and then the way that this will work is they'll both have an opportunity to share sort of a high-level picture of what are they working at on this issue in their country. And then they will have an opportunity to sort of share and discuss some commonalities and differences across some different issues, some case studies. And then we will open it up for Q&A, and we aim to end sharply on the hour. So without further ado, I'm delighted to introduce Orly. Orly holds a bachelor's degree in law from Tel Aviv University, and she has interned at Israel's Supreme Court. And then afterwards, she got her master's degree at Columbia University with a focus on human rights law. She's a member of the bar in both Israel and New York. She's been an attorney at her present organization, the Israel Religious Action Center of the Reform Movement, since 2004, and she's been director of their legal department since 2014. Orly has brought about significant legal achievements since that time. In the past, I guess it's been how many years, Orly? 16. She's made gender segregation on public transportation illegal, just a small thing. She's worked to end the Orthodox monopoly on state-funded salaries to rabbis and ensure that state funding goes to the construction of non-Orthodox synagogues. Thank you, Orly, for joining us. Let me now introduce also Noa Mendelsohn Aviv. Noa is the director of the Equality Program here at the Canadian Civil Liberties Association, the CCLA. Noa joined the CCLA in 2002, right around the same time that Orly joined IRAC, as a legal researcher. And since 2005, she's directed CCLA's expression and equality programs. She also manages their law student volunteer programs. She has an LLB and an LLM from Hebrew University in Israel and a BA with distinction from York University. She completed her articling at the Association of Civil Rights in Israel, IRAC, also one of NIF's sort of flagship funded partners in Israel. And she was called to the Israeli bar in 1998. She worked for a few years for a law firm in Jerusalem, and she's worked for a field coordinator also for a large research project on eating disorders in women, and has been an acting administrative director of Hebrew University's Law Faculty Center for Human Rights. I'm delighted to have both of your expertise here. I'm really excited. I believe, Orly, you're going first? Yeah. Please.
Hi, everyone. It's great to be with you. Good afternoon. It's evening here in Israel. One biographical fact that I should mention is that I was actually born in Canada, in Ottawa, when my parents spent a sabbatical there, and I came back to Israel as a baby. So I'm a Canadian citizen as well. I'm working for IRAC, as Ben has said, for almost 17 years, and we have been working to make Israel a more inclusive society, promoting tolerance, equality, and pluralism in Israeli society and on different issues, freedom of religion, fighting gender segregation and exclusion of women, fighting racism and incitement to racism. And one of the areas we've been focusing on is LGBTQ rights, something that we've been working on for many years now. So just before I give you just a few examples of the things we've been doing on this area, just a few words of background on the Israeli legal system in this regard. In Israel, we don't have a written constitution, but we do have a set of basic laws. The most important one regarding to human rights is the basic law of human freedom and dignity. Interestingly enough, this basic law does not mention the word equality, but it has been interpreted by the Supreme Court to grant equal rights to all Israelis. Actually, today in the parliament, there a bill came up to amend this basic law and to insert the word equality into it, and it has actually been approved, but it's just a very preliminary stage. It won't go through. But still, all citizens in Israel are at least should be granted equal rights, and therefore discrimination on the basis of sexual orientation is illegal. We have another very important law that was passed in 2000, which is basically an anti-discrimination law, which states that any place offering services to the public, even if it's a private place, is not allowed to discriminate on the basis of race, religion, national origin, and sexual orientation. And this is a law that we have been using quite a lot to fight all sorts of discrimination, and also discrimination on the basis of sexual orientation. In Israel, as you probably know, issues of personal status are completely controlled by the religious institutions. And therefore, when we're talking about marriage and divorce issues, for Jews in Israel, they have to go through the ultra-Orthodox chief rabbinate. And this institution, of course, does not recognize same-sex marriages. So basically, gay and lesbian marriages cannot be performed in Israel. I mean, they can be performed, but they're not recognized as such, as marriage. However, if gay and lesbians go and have a marriage abroad in one of the states that recognizes such marriage, they can be registered when they go back to Israel as a married couple, and will be entitled to basically all of the rights of married couples. Since there isn't civil marriage in Israel, over time, both the legislation and the courts developed the institution of common law marriage. And so basically people living together without being married or without being recognized as married by the state are entitled to most of the rights under Israeli law. This goes both to heterosexual couples and gay and lesbian couples. There are a few areas where there is still difference, and one of this is the issue of basically having a family, issues of both surrogacy and adoption. In Israel, under this current surrogacy law, only a heterosexual couple or single women are allowed to become surrogate, to have babies under surrogacy. This has been part of a long legal process. The court ordered the state to amend the law because it was deemed unconstitutional, and the parliament has still not done so. And the same goes for the issue of adoption. Actually, the case of adoption is something that we have been dealing with. We filed a petition to the Supreme Court of Israel in 2016, because the current adoption law states that only a man and a woman are allowed to adopt babies. So only a heterosexual couple is allowed to adopt babies in Israel. And the current reality is that if you're not under this category, you will only receive babies that other people, that heterosexual couples will not want. So basically older kids or kids with problems or disabilities. We have filed the petition asking the court basically to strike this down. And again, in this case as well, the state said that they're going to change the law. Actually, it was interesting because at first they said they shouldn't change the law because gay and lesbian families are abnormal. And since being adopted is abnormality, you shouldn't add another abnormality to it. And this caused a huge outcry on the Israeli media and public, and 2 weeks later they changed their position and filed a new position to the court stating, you know, we changed our position and we are going actually to change the law in order for all couples to be allowed to adopt babies. They haven't done this. So actually today another bill, a private bill, was brought to the parliament. You know, the Israeli political system is in a great turmoil and the whole thing is falling apart. So like they're promoting and bills just for the very last days or weeks of the current parliament before we go into yet another election process. But this has not gone through. So still the law hasn't changed, and we still see the difference when we're talking both about surrogacy and adoption. I want to tell you about 2 other cases. First, the issue of marriage. In the last summer, because of COVID-19, many people were not able to have their weddings because all the venues were closed and because there were restrictions on how many people you could invite for an event. And so many municipalities around the country decided to start a project where they allowed people to have their weddings on parks and beautiful venues in the city. And the Jerusalem municipality joined this initiative and offered this as well. But they said that this initiative is only open for people who marry through the chief rabbinate. So basically for only people who are eligible to be married in Israel. And this, of course, does not include gay and lesbian couples. We filed a petition to the court. The Attorney General of Israel decided to join the case because he deemed it important and basically supported our position that this is the Jerusalem municipality basically infringes the law and should open it to any couple who wishes to marry. Unfortunately, the municipality did not accept it and decided to end the project altogether. And we actually these days are working on a class action suit against the municipality on behalf of all the couples that were not allowed to participate in the project. So we see that there's a lot of, still a lot of work ahead. And the final case I wanted to mention at this stage is about the Jerusalem gay and lesbian organization called the Open House for Pride and Tolerance. We have been representing them for many years on different contexts, and one of the issues we've been representing them concerns the fact that they have not received any municipal funding from the Jerusalem municipality, although they render a lot of services to the gay and lesbian community around Jerusalem. There have been a few criteria they applied for, and every time they applied, the municipality quickly changed the criteria to make sure they're not eligible to receive financial support. And we have actually, the Supreme Court accepted basically this lawsuit in a very important decision. It's actually already a decade old. It was in 2010, and said that basically when there is a whole sector of residents in Jerusalem that are not eligible for support, whereas others are eligible, this is an illegal situation, and therefore they forced the Jerusalem municipality to support the Open House. And actually since then, the municipality has been supporting the Open House for hundreds and thousands of shekels each year, which unfortunately it's not enough because other sectors receive more, but it was a very important case stating the importance of supporting the gay and lesbian community. We have been assisting the Open House on the issues of the Pride Parade. Each year we have a Pride Parade in Jerusalem, and always there's a big fuss both with the police allowing us to march in central Jerusalem and with the municipality, which they're supposed to allow usage of the parks and also hanging pride flags. This year we actually took them to court because they refused to hang the pride flag. So each year we have more and more legal battles, and we assist the Open House to make sure that they receive basically equal treatment. So this is just a little taste of what we've been doing, and I'm sure we'll continue later with more cases.
Just a few, just a taste. Wow, rapid fire. Thank you, Orly. Noa, across the pond, here at home, you know, what does our situation look like, and what have you been working on?
I think this will work better if I unmute. So here in Canada, things are different, and I couldn't begin this talk without saying that they're different in part thanks to the efforts of a certain Joe Arve, who was a phenomenal civil rights lawyer who fought, amongst other things, for the rights of queer people and did it exceptionally well. And he passed away 2 days ago. So I had to mention his name. He also was on a fight against solitary confinement for the CCLA at the same time that the Canadian Civil Liberties Association, where I work, was fighting solitary confinement. And so we've had some various opportunities to work in tandem or together. Okay, so things are different in Canada. And I wouldn't normally give a history of where we've come but I thought it might be worth doing it very briefly today as a contrast to where things were in Israel. And also to get a sense of how much things have changed because we're gonna end up talking about backlash. So decriminalization of same-sex sexual activity was in 1969. That's 50 years ago. And I believe there might be some people on the call who would have been alive at that time, but if not, it's not that far away. And things have been changing at a rapid pace and a more rapid pace ever since. In 1977, saw the first provincial legislative prohibition on discrimination on the basis of sexual orientation. And then that continued for the years after that. And the federal recognition, the Supreme Court recognition that sexual orientation is a prohibited ground of discrimination in the famous Egan case in 1995. And the provincial laws in 1997, if they didn't already recognize that you could not discriminate on the basis of sexual orientation, the Supreme Court said, well, you have to. And that was the Murane case, Murane v. Alberta from 1997. Following which you have recognition of benefits for same-sex spouses, recognition of the right to adopt, it's from 1996, as well as the earliest recognitions that I was able to find in the case law for trans individuals from 2000. But at that time, not because gender identity or gender expression were recognized, but because it was easy to fit them in under the grounds of a prohibition on discrimination on the basis of sex or disability, which is not the optimal way to go. And that changed as well a little bit later, which I'm going to get to in a moment. There were successful case laws in which Canadian Civil Liberties Associations intervened in many of these cases. One of the big ones was Chamberlain, which was about materials in schools by a teacher who very deliberately, a teacher who was part of an organization called the Gay and Lesbian Educators, wanted to bring some materials showing other kinds of families. One dad, two dads, red dad, blue dad was one of those books he wanted to bring into his classroom. And in the famous Chamberlain case, he was successful at the Supreme Court. In 2012, there was, and in the year or so leading up to it, we were very involved in the push to make schools safer places for queer students. So we took an active role in getting a change to rules, including in publicly funded religious schools that should allow gay straight alliances. This is student clubs in schools. And when the legislation was changed, CCLA made our submission to the Ontario Legislative Assembly saying, when you recognize homophobia as one of the things that needs to be addressed, you need to include transphobia as well. It was not until 2017 that our federal anti-discrimination legislation was finally amended to include the words gender identity, but it had happened in many of the provinces before that. And today, trans rights are recognized to a large extent in law, including things like the right to change your legal gender, including without sex reassignment surgery. And this applies to most people in Canada, but not for people who are temporary residents or asylum seekers, and that requires a bit of an individual battle. As well, there has been some legal success in the case law with provinces now, some provinces now including a non-binary option on certain identity documents. So the possibility of having an X or the possibility on certain documents of not having sex listed at all. Some of the interesting and difficult cases that CCLA has also been involved in, two of my favorites were the Marriage Commissioner's case and the College of Physicians and Surgeons, the Christian Medical and Dental Society case. The Marriage Commissioner's case was a reference, for those of you who aren't lawyers or aren't from Canada, reference is when the Parliament or Legislative Assembly asks the court to opine on the constitutionality of a law before it gets passed. And in that case, it was a law that would have, when same-sex marriage was recognized in Canada, the province of Saskatchewan said to the court, what do you think of a law that gives an exemption for marriage commissioners, civil, non-religious, non-clergy marriage commissioners who refuse? What about a blanket exemption? Or what about an exemption for people who were marriage commissioners before? In other words, a grandfather provision. It's one of my favorite cases because in it, the majority said, no, those kinds of exemptions would not be constitutional. Somebody who's being paid by the state and is acting as an agent of the state cannot discriminate, and it's bad for people. And in any case, lots of people would then refuse, and where are gay people going to get married? And the dissent, I guess it was a concurrence, went even further and said, and the reason it's not constitutional is not only because it's not proportionate and not appropriate. We recognize that there's religious freedom, but the reason that it's not proportionate is because the very objective of these exemptions is not religious freedom, because there were always people who could have objected before. The reason you're bringing this in now and the reason you'd be grandfathering in people from this date is in order to allow people to exclude and to refuse to marry same-sex couples. Not anybody, same-sex couples, that's what you're after, and that's not a legitimate objective. The interesting piece to that, and we can talk some more about religious refusals in a bit, is that the same dissent concurrence also talked about how important it was to some of those marriage commissioners not to marry same-sex couples, that they saw it, and the quote is, as invoking the righteous judgment of God. And then the concurrence continues merrily along to say, well, nonetheless, it's really not a problem for religious freedom, and so we're going to strike that balance. And it was the correct balance, and CCLA was in the case to argue that it was the correct balance. But it was interesting to note, as an organization that also promotes religious freedom, how little understanding there was on the part of the court in that case for what religious freedom means for people for whom it's important. And it's something that we're coming up again in a very different context in our Bill 21 challenge about the ban on religious symbols in many public sector jobs in Quebec. And we're in trial at the moment right now in Quebec on that point, with many of the witnesses having to explain to the court that religious freedom actually means something to people who are religious, and that includes wearing certain objects or having certain religious symbols. So that's an aside. So where are we in terms of the next frontier? So I'll say this briefly, and I'm happy to expand on it, but the funny thing about discrimination, other than it's not funny, is that it's a little bit of a shapeshifter, and that when discrimination is happening in the moment, people who are trying to justify it don't say, I want to hate or I want to be a bigot. They say, I have good reasons. And that was true before gay rights were fully recognized or understood, where people said it's just a lifestyle choice, it's just an option. And then about marriage and adoption is bad for children, and kids need a mom and a dad. There were what appeared to be reasons. They weren't necessarily evidence-based. In fact, they weren't evidence-based, and people were able to bring evidence to the contrary saying, no, children need loving parents, and it doesn't matter, what their gender is. And the wool didn't lift from our eyes and from society's eyes until those rights started to be entrenched and after people had started to fight for them. And the same can be said for many, many other forms of discrimination. So, if you look at something like anti-Semitism, a lot of people don't say, other than Roald Dahl, a lot of people don't say, I hate Jews. They say things like, they're the moneylenders, or they control society, or there's a conspiracy, or I hate Israel. I hate what the Israeli government is doing, and so I don't like Jews. And we hear that in Canada, and it's one of the uncomfortable tensions that we live with, even if we also are critical of what the Israeli government is doing. And I think that kind of justification is applied in the context of trans people still today, where a lot of people don't understand about gender identity and don't understand that this is in fact real. And it's one of the challenges that people face, and in particular in the UK, where there's a real war of sorts between a particular and a very small segment of feminists and people who are fighting for trans rights. We have a tiny bit of that in Canada as well, but it's not not very strong. For the most part, there is an understanding of intersectionality and an understanding that the oppression of women, which is based on patriarchy and violence and misogyny and perhaps also white supremacy, is inextricably linked to the oppression of trans, non-binary, and other queer individuals, and inextricably linked as well to the oppression of Black, Indigenous, other racialized people, as well as, and here's one of the new frontiers, people living in poverty, people with mental health issues, people experiencing homelessness. So if we look at the remaining rights, we have to look at things like violence against racialized trans people. We have to look at issues of homelessness because a greatly disproportionate number of homeless youth are queer. And many of them are afraid to go into shelters because of violence inside the shelters against them. And now even more so under COVID, and CCLA is actually challenging the City of Toronto together with a coalition about the problems within the shelters and the lack of safe spaces within shelters and for people experiencing homelessness. And issues in schools, our organization challenged a change to the sex ed curriculum. There was a program that included gender identity and sexual orientation. And our current government, one might say part of the backlash, changed the sex ed curriculum, brought in an old one that removed reference to, or didn't have reference to, gender identity, sexual orientation, different kinds of people, different kinds of families. We fought it and we won in a little bit, but mostly lost. And again, I'm happy to share more information about all of that, but I want to end on this note. We've come a huge distance in a short amount of time. That time is getting shorter and shorter. And we need to see where we're going next, but we can't see it passively. The backlash is strong and it's going and it's growing. So my takeaway would be that if there's one thing that what we need is to do everything in our power, whatever we can, to fight the backlash and make sure that equality wins.
Thanks, Noa. Two very, very different contexts, two very different legal, situations. But I think there's, on its face, they may seem very far apart, but I think both Orly and Noa look at these things from slightly different issues. They are approaching it from there is still a conversation to be had a little bit deeper in as you get into the details of like, what is the balance between this right and that right? So I think Orly, are you prepared to open up the discussion first?
Sure. So I think a very interesting question arises in one of the issues we've been dealing for many years now, which is the question of whether a religious figure who is part of the state service, who is a public employee, state employee, and I'm talking specifically about rabbis in Israel, what is their scope of freedom of expression and whether their freedom of religion allows them to say harmful expressions, harmful sayings against different populations, among them the LGBTQ community. And we've been, IRAC has been focusing on preventing people who use the Jewish religion to incite hatred and violence and exclusion. And we've been complaining about, unfortunately, quite a few rabbis who are part of the public system. They're employed as city rabbis or as neighborhood rabbis or as regional rabbis. We don't have any separation of religion and state, and therefore the state pays the salaries of many rabbis all around the country. And they use their posts to incite consistently against many populations, mainly, by the way, incite against Arabs. And in Israel, under the criminal law, it is a criminal offense to incite racism and violence. But when we're talking about incitement against the LGBTQ community, it does not go within the boundaries of the criminal offense. And so it is not illegal for anyone to say it. It is part of freedom of expression. But when we're talking about state employees, there is another layer of disciplinary system. And we have been asking the appropriate authorities to put those rabbis under disciplinary proceedings for harmful and insightful expressions against the LGBT community. And we've had quite a success just a couple of months ago with the Supreme Court decision regarding one of the rabbis who incites the most, unfortunately. His name is Rabbi Shmuel Eliyahu, and he's the city rabbi of Safed in northern Israel. And he's been inciting for many, many years, mostly against Arabs, but also against the LGBTQ community. He's been saying things like that, being an LGBTQ is an abomination, that the LGBTQ community incites, basically uses terror to that everybody will be scared to talk against them, that being again lesbian family is an illness and abnormal, and of course because every family needs to have a mother and father, saying this is a distorted life and an evil culture. We have brought all of these things before the court. The court decided to accept our petition and ordered him to be under disciplinary charges. But it was interesting because the justices differed. It was a panel of 3 justices, and they differed on what is the criteria under which a rabbi would be under disciplinary charges, what is sayings which would be allowed under the freedom of expression, and what sayings would be out of the scope. The judge who wrote the majority opinion, I would say, stated that there are, of course, limits, because as a state employee, you should not be allowed to say whatever you want. You have to respect all sectors of society. And we're talking about sayings which are harmful to other sectors, they're not allowed. However, unfortunately, specifically, he did mention that sayings which go against the LGBTQ community, if they are sort of just citations of the halakha, of the religious scripture, then it is allowed, as long as it is really something that is meant to convey the religious message and not just, using a derogatory term. However, the other 2 judges who concurred with his decision sort of framed it a little bit differently. They said that any derogatory frame, even if we're talking about something which is on a religious basis, should not be allowed to a state employee if it is harmful, if it is insightful against the different sectors of society. And so this is sort of, we don't have a very clear message from this case because we have slight differences in the opinions, but it did mark an important sort of red line, that if people cross it and they're employed by the state, they're not allowed to do so, and they would be under disciplinary charges. And me and Noa had sort of this conversation before this, before today, and I think this is a very interesting issue on where to draw the line. Of course, on the one hand, you have the freedom of expression and freedom of religion. Both of them are important basic rights in Israel as and in Canada. On the other hand, when we're talking about someone who is part of the state service, and of course, all of us pay his salary, and he's supposed to represent all sectors of society, I believe that he should be restricted, that his rights for freedom of expression and freedom of religion should be restricted. And I think that even if we're talking about ideas which are conveyed as religious ideas, they should not be allowed to be voiced by a person who is in such a position, specifically when we're talking about senior positions, such as a rabbi of a city. So I know Noa has maybe a slightly different view on the issue. I would be happy for you to share your thoughts on this.
I have slightly different views, but also similar views. I mean, the CCLA has a long history of protecting the right to freedom of expression, going back to a time where freedom of expression was critical to protecting the rights of queer people, of being able to say things and have pride parades. That was a freedom of expression issue. For people to stand up for women's rights to reproductive justice, et cetera, et cetera. Like we know how important freedom of expression is for the protection of minority rights and unpopular rights. And especially considering what I was saying earlier, that in the early days, you don't know discrimination is discrimination. You know it as something justifiable and necessary. And it's only later and with research and understanding and theory that you come to understand that this was simply bigotry and often unfounded and often without evidence. So one of the issues that came up that really raised a lot of interesting discussions at our organization involved this woman named Megan Murphy, came to speak in Toronto. She's from the West Coast, and she's anti-trans. She says that she's not, but then she uses language that makes it really clear that she is. So she says things like, well, I just think that allowing men to identify as women is bad for women. So that's a very clearly coded language anti-trans statement, but still a far cry from the kind of incitement that you're talking about, Orly. And the Toronto Public Library System has a program in which members of the community can use public space as public space. So they put on their own events, the Toronto Public Library System, but in addition to that, the spaces that are available, community groups can use for various kinds of meetings and gatherings. And one group booked a Toronto Public Library room to invite Megan Murphy to speak. And there were huge protests about it. And the head of the library system, who does understand the value of freedom of expression and should, and some of those librarians have been really helpful to CCLA over time when we fought against various kinds of censorship. But she took a strong stand and she said, this is not a library event and people can book this room, including these people. But I agree with you, the question of where to draw the line is a very difficult one. The other case that we were involved in that is so relevant to this issue, it's a long time ago now, was one called Owens, also from Saskatchewan, in which this was just before same-sex marriage was recognized across Canada. And it was an active debate. And you can debate whether or not it was a legitimate debate, but certainly there were discussions going on. There had just been a pride parade, and Mr. Owens puts out an ad in the newspaper that he's selling a bumper sticker. And the bumper sticker has two little stick figure men holding hands and a circle and a line. You can't see my hands on the Zoom, and a circle with a line through it, and equals. And he cites 3 biblical passages. He doesn't have room on his bumper sticker to put the wording, but it says Leviticus 19:20 something and Romans something and Corinthians something. So he's got biblical verses. And it's certainly one of those situations where hamivin yavin, right? Like if you know what's in those passages, you know that they say some really, really hateful homophobic things, including incitement to violence, potentially, if you read it a certain way, or if you read it another way, it just means the Bible says homosexuality is wrong. But the passage from Leviticus, and forgive me because it's brutal, says if a man lies with a man as with a woman, they have done an abomination. They shall be put to death. Their blood shall be on their head. So it's hateful and awful. And if you saw the advertisement for this bumper sticker in the newspaper and you knew your Bible or you went to look it up, is that close enough to see kind of an imminent incitement to violence? Maybe not. And in this case, CCLA came forward and supported the right to freedom of religion and freedom of expression, not because we like that kind of speech. We don't. We've been fighting for individual rights and queer rights for many years, but because it's hard to say that you should ban the Bible. And so I'd be curious what your position on it. The other place where it comes up and where we've taken a different position has to do with education. There's the Trinity Western case, which I won't get into now for lack of time. But there's a really interesting case, part of the backlash that came out in Alberta, when for a brief moment, the province had a progressive government. They passed legislation saying that schools should have GSAs and they should treat trans kids with dignity and use their real names and their real pronouns and so on and so forth. And by real, I mean the ones that they've chosen. And a group of parents, religious parents, got together and said, and filed a claim saying, if our kids change their names or if they join a GSA, we should be informed about it. And the legislation did not allow for this. And they tried to get an injunction and they were unsuccessful. But of course, that little window of progressive politics in Alberta closed. They now have a conservative government. The laws are back to being what they were. But the reason I mention it is because schools is one of those areas in which there is public funding. In Alberta and Ontario, both for non-religious schools and for, in Alberta for different kinds of religious schools, and in Ontario for Catholic schools, neither of which promote queer rights. And I don't know what happens in some of those schools and whether they read from the Bible. And which passages?
Orly, you have just a minute or two to add anything you want, and then I think I'd like to open it up for Q&A from all of our attendees.
Well, I think following what Noa said, I think that we cannot bar the Bible, but going back to what I said, I think that when a person, you really have to distinguish between a private person and a person who is part of the public system. And I believe that if someone is part of the system, then if you're sayings from the Bible, which are harmful and derogatory and demeaning for other sectors, then you're not allowed to say this. And I think in this decision I mentioned, the judges said, well, if you want, your freedom of expression not to be restricted, you're free to leave the public service, go ahead, do whatever you want, but you'll have to understand that you have certain restrictions. And I think that it's really, especially in Israel, where you really have no choice, we have the system as part of the public system, we don't really have a choice. I think we really have to put these restrictions. Clearly, freedom of expression is really important, but I think those restrictions are important as well to protect other values. I can say that it's the same as we fight incitement to racism. I can tell you on a different note that we basically worked to disqualify racist candidates running to Israel's parliament last year in 2019, which was the first time the Supreme Court disqualified candidates because of the racist since Meir Kahane was disqualified in 1992. So I think on the extreme cases, you should really draw the line and say this is not part of what we're allowing. Even though there is freedom of expression, freedom of religion, because it really goes beyond the red line.
Thank you, both of you. So very, very interesting. At this point, we'd like to invite people, if they want to ask a question, please, like all you have to do is raise your hand. You can put a question into the chat. Just turn on your video and wave at us, and I'll call you in order. I see a question from Miriam. Let me see. I don't see any other questions at the moment. Otherwise, I'll call them in batches, but I guess Miriam, you're the only one at the moment. So go ahead.
Is there a legal definition of queer?
Pardon me?
Is there a legal definition of queer? Or is it a self-application?
I don't know the answer to that. I think it's become more and more common. I think for the most parts, the courts are still using LGBT or LGBTQ or LGBTQIS. And it's important, obviously, to have the recognition of the different kinds of identity within the queer community, but it also makes sense to me that a lot of the younger folks have said queer is a good word and it kind of covers the umbrella. I don't know if I've seen it in the courts, and I'm fairly certain I haven't seen it in any kind of legislation.
Is there anybody in the other categories of LGBT who object to the word queer?
I think, yeah, I mean, I think there's a shifting consensus around it. I mean, there was a time even a couple of years ago where some of the younger students who came through CCLA's doors, we work with a lot of law students that come and volunteer, and they were using the term queer, and I sort of said, is that an in-group thing or an out-group thing? But I think it's become really quite accepted in most mainstream LGBTQ plus rights advocacy groups for everybody to use. But it's an important point, and I'm glad that you asked it. And perhaps I should have clarified, because of course, it's not that long ago that it was used exclusively as a derogatory term. And the fact that it's been reclaimed as something positive and joyful and celebratory is wonderful, but it should be clarified. So thank you for asking.
I bring it up, if I may, with a follow-up, because now that people are using their own pronouns, I'm just wondering whether the usage of pronoun, of using he, she, I've seen she, husband, I mean, all of these different things, it makes it difficult for somebody who wants to be sensitive not to insult somebody by using the wrong word.
Yeah, I think there's been an enormous amount of change And I think it's happening rapid fire as we speak. I mean, my kids I've got 2 kids in high school, and they are, you know, more and more often coming home and talking about people with new names, new pronouns, and sometimes mixed pronouns, you know, she, they. And we've had dinner table conversations about what that means and how you use them. Does she, they mean pick your choice? Or does it mean please insert both into a sentence, which is what my kids think? I think the etiquette around it is going to need to catch up as well. And the best we can do right now is to, you know, be as respectful as we can. So I think that is important. And what's more important, of course, is that there are people who deliberately don't understand and deliberately make mistakes or use dead names or refer to a person using the wrong pronoun and pretend that they don't understand.
If I may add, I think that in Israel, we're sort of lagging behind Canada, a few years behind, but I would say that in general, it's really the public awareness to, of course, the need to equal rights for the LGBTQ community has been on the rise tremendously. I mean, you cannot compare the situation today to what has been going on a decade ago. Today, the example I said about incitement against this community arise a lot of public outcry. We have headlines on the media. If politicians say this, they usually apologize. So it's considered illegitimate to talk like this. And in this sense, I think we've made a great development. There's a lot more awareness, a lot more sensitivity, and you know, we still have a long way to go, but I think we've made a long way comparing to a couple of years ago.
And that's saying a lot for a society where, you know, 20 odd years when I was living there, the idea that anything could be insensitive and out of bounds was considered ridiculous.
So we have a related question in the chat. Tal is asking, you know, most achievements in Israel have been thanks to court decisions, which might be overstating it, but I think we certainly see that court decisions have been a pillar of protecting liberal values in Israel over the past decade for sure, and before. But what would be the impact of he's asking, what would be the impact of politicizing the courts in the past years on human rights? Certainly it's a major issue in Israel as the courts can increasingly come under fire as being a political voice and not a neutral voice. You know, how does LGBTQ issues square in with the strategy of relying on the courts to advance these issues?
So I think that it is true that in general, we made progress specifically, mainly through the courts, not only on LGBTQ issues, but on human rights issues in general. Israel's parliament has been a very difficult arena to work in for many, many years now. And it is actually just becoming worse and worse. So we really don't have a choice but to go to the courts. And it's true also that the courts have been under severe criticism in the past 4 or 5 years. I think that still, if you look at the public trust on different governmental institutions, still people would trust more the courts than the parliament or the government. But it's true that, you know, the prime minister, of course, who is going through his criminal trial, and other politicians have been very criticizing the court tremendously. Still, I think that still in Israel, when we have usually a decision of the court, the state would follow, even though sometimes it's too late, but this is still, I think, a very important route to go through, and we don't really have other routes except, like I said, media and public pressure, social pressure, which is very important in, you know, pressuring politicians to carry on their promises, and eventually it does influence the court as well. You know, the justices sit here and they're part of the society. So I think it's really important in that sense too, the fact that you hear about it in the media, it makes headlines, people talk about it, there are demonstrations, if people, you know, people will go out to the streets if they feel that their rights are not granted to them. But still the courts are one of the major venues to go through.
Yeah, if anything, I think, you know, as an organization, the New Israel Fund in Israel has seen that, you know, it seems like a lot of issues are not making a lot of progress in Israel over the past years with sort of populist, nationalism that we've seen in Israel, and the corruption at the top, and the impasse on especially Jewish Arab issues, conflict, rights of parties. Significant changes happen, and I think probably Noah and Orly can speak to the fact that the change in public opinion on the rights of LGBTQ individuals now enjoys a majority of public support, even though the majority of public support is not reflected in the governing coalition. But that is hands and shoulders different than it was 20, even 10, 20, 30, 40, certainly 40 years ago when, there wasn't, when civil society in that sector was just starting. I don't know if there's anything that you want to, any flavor.
I just wanted to add that Tal added a follow-up question about how justices are being elected or judges being elected, and the fact that the politicians influence the identity of the judges. So in Israel, I think the election, the current election process of judges is up till now is okay. They want to change it, but basically it's done by a committee which is comprised by representatives of the government, the parliament, the bar association, and the Supreme Court. And the way it works today is basically that you need the agreement of both the justices of the Supreme Court and the politicians. And so usually they reach a compromise under which they promote both conservative judges and liberal judges. They want to change this now. They keep talking about changing the system, but as long as it works like that, you do usually strike a balance. So they do not nominate only conservative judges, but usually it's like compromise. And so it might change because we're going to have a few justices who are going to retire in the next couple of years. But for now, we still sort of have a balance. We now have a majority of liberal judges on the Supreme Court. It might change, but hopefully the current system works relatively well.
I sometimes naively think that it's hard to be educated and not recognize certain realities. I mean, you can have a different political orientation, but at the end of the day, when you're forced to look at evidence, it's hard to draw the kinds of conclusions that certain kinds of bigotry would promote. Like, for example, as I was mentioning earlier, around things like adoption of children and, who can provide a living home and what it means to kids not to have that available to them. In Canada, of course, the situation is a little bit different. It's not a highly politicized process, and our judges really try and maintain that sense of professionalism, legal excellence, so that even if they have a particular political bent, it's not how they make their decisions, and that they tend not to stick their necks out, not to be very activistic. And in fact, our courts can be quite conservative. So a lot of the changes that we've seen in the courts were changes that happened through social engagement and pressure and activism on the parts of organizations, like CCLA, like the ones that the New Israel Fund supports as well in Israel. And then when that groundswell of support, of academic writing, of understanding, of op-eds and so forth is enough, then there's enough room for the courts suddenly to understand it as well. So I don't know that it's necessarily what happened in the courts, if not for the groundwork that is done. We saw that around refugee rights in Canada, and I think same-sex rights as well. In fact, on the interesting story of LGBTQ plus rights in Canada is the story of how we got same-sex marriage equality, because there was a group of lawyers who was working together and who were holding each other back and who decided to be strategic about it and take baby steps. First, we're going to get sexual orientation recognized as a ground of discrimination. Then we're going to fight for equal benefits. Then we're going to talk about adoption. And nobody in this group, nobody should go forward and fight for same-sex marriage until we have those things firmly and solidly entrenched. And that was a strategic decision that they made, and it was successful. Canada was the 4th country in the world to grant same-sex marriage rights. Federally, nationally.
I think we have time for just one time to let them go at the hour. Do we have any other questions in the chat, or raise your hand? 2 minutes to sort of finish, to say anything you'd like to say in conclusion, and then I'll wrap us up and let us go.
Just really to conclude, I think we've made a lot of progress. I think that, I defend the rights of different sectors. I defend the rights of women, of Arabs, of LGBTQ, of Reform and conservative Jews. And I think really LGBTQ are one of the sectors which are, it's easier to defend their rights because it's really within the consensus. Unfortunately, racism against Arabs and incitement against the Reform movement and gender segregation against exclusion of women is very widespread, and people have different justifications for it. But I think that when we're talking about the gay and lesbian community, we are in a different place right now. And in this sense, I think I'm very hopeful that we will continue with the achievements on this issue and also have additional achievements on other areas as well.
I guess for me, I'm grateful to be in Canada. I'm grateful for the work that's been done and how far we've come. I'm particularly grateful to see how some of the leading organizations have really taken seriously the idea of an intersectional analysis, where the leading feminist organization understands the connection with the rights of people of varying sexual orientations, gender identity, gender expression, and the leading queer rights organization understands the connection to patriarchy, and have helped teach organizations like CCLA that looks at the breadth of rights. So that, for example, in the abortion rights challenge that we're mounting very soon in the province of New Brunswick, when we talk about the rights, who needs an abortion, we know that we can't silence the voice of women. We don't want to make women invisible, but we also don't want to make trans people invisible, non-binary people invisible, because sometimes they need an abortion as well. And so we include all of them, and we mention all of them, and turns out it's not that difficult to do, and it actually is all interconnected. I guess the only other point that I want to bring up, which I touched on briefly at the end, is that if our next frontier is about what we don't recognize today, our challenge is going to be about what the courts call positive rights. So the same way that they said, we're not going to force the province to have sex education that includes gender identity and sexual orientation in schools. We can't show diverse bodies, we can't show diverse families to kids, because that would be a positive rights issue. We're running into the same kinds of issues around things like homelessness. But the fact is that homelessness leads to death and spread of disease. And we see that now during COVID more than ever, how dangerous shelters are, how critical it is for people's physical and mental health to have a space that they can feel safe in. And so we all are going to be required on an ongoing basis, both to do our best to support these rights and to allow ourselves to be flexible, to expand our thinking about it.
Thank you so much, Noa, for joining us and for sharing your expertise. Thank you, Orly, for sharing your expertise and for doing the work in Israel that we are so very proud to fund. I want to thank again the members of our. I want to thank again the members
so much
of our,
for allowing us to do our work, for supporting us, and
you both inspire us we're members of of both worlds, Israel and Canada, and so we stand by these values. We appreciate your work, and thank you to the members of the New Israel Fund of Canada's legal circle for helping organize this event. And we will be doing many more of them, so please stay tuned. And for others who would have liked to have joined today's session, we will be posting it online. Please be in touch. People can get lawyers who wish for CPD credits can still get their credits by watching the recording. So again, thank you all very much, and have a good rest of your day.
Thanks, Ben and Hannah. Thank you, New Israel.
Thank you. Thank you.